I were the owner of a commercial construction project, my first choice for an owner contractor agreement, all things being equal, is going to be AIA document A101-2017, the basic owner contractor agreement. To me, this is the flagship AIA owner contractor agreement for commercial projects. That's not to say that there are not other forms that I use frequently, including the A102, which is an owner contractor agreement when the contractor will be paid on a guaranteed maximum price basis. But all things being equal, if I had my pick, I would prefer to use the A101-2017 for a variety of reasons, including the fact that it is the simplest to use and tends to be the least dispute prone. So in my experience, my owner and contractor clients are most likely to succeed in a project and have win-win outcomes, good construction work for a fair price, projects delivered on schedule, no surprises, no disputes, when they use the A101-2017 because it is the simplest to use and the most straightforward in terms of the pricing mechanism and other essential features of the document. It's important to remember that this particular document works for the standard project delivery method, what we refer to sometimes as the tripartite method of project delivery, where the owner up here separately enters into a contract with the architect, and then the owner separately enters into a contract with the contractor. This is the document we're referring to here. This is the A101-2017. This would not be appropriate for other project delivery methods. For example, a design build project or a project where the contractor may be functioning as some sort of a construction manager, either at risk or just as an advisor. The main feature of the A101 that I really like is the way that it looks at contractor compensation. This is a document that assumes there will be a fixed contract sum, which is sometimes referred to as a stipulated sum or a fixed price. And if you think about it, it's the blinding flash of the obvious that the contractor is not going to be able to quote the owner a fixed contract price and is not going to be able to promise scheduled deliverables unless and until the architectural and engineering drawings have advanced to the point that the contractor is going to be comfortable providing a fixed contract sum and a delivery date. So this project delivery method assumes that the owner is first going to go to its design professionals, that it is going to have drawings created that are complete enough. I'm using air quotes because they don't necessarily have to be 100% complete, but complete enough for you to then take these drawings to a variety of general contractors and see what price and schedule they're willing to offer. This is a document that works in what we sometimes refer to as design bid build, where the design comes first, followed by bidding, and then ultimately the selection of a contractor and construction. Design bid build works for private projects and for public projects. Its sister is design negotiate build, which is typically something that we would see on a private project where the owner will take the drawings from the design team to an individual contractor and negotiate a price with that contractor and then execute the contract rather than open it up to bidding by a bunch of unaffiliated contractors. All things being equal, the reason why I prefer the A101-2017 is because it's simple. The contractor is going to give you a fixed price. It's going to give you a schedule. Of course, we all know that every single project is going to have change orders. The schedule is going to move. The contract sum will be adjusted over the course of time, but it tends to be simpler to administer than what we refer to as cost reimbursement contracts, which are sometimes called guaranteed maximum price agreements, because rather than have a fixed sum that the contractor agrees they're going to construct the project for, what we have in those cost reimbursement situations is a ceiling, a guaranteed maximum price, and then the contractor is going to be able to spend up to that ceiling. And the hope is that there may be some savings that the owner and the contractor can share. So in my experience, that owners who chase savings are almost universally disappointed. The savings tend to be illusory for a variety of reasons that I cover in other videos, and I discuss specifically when I talk about the A102-2017, which is the AIA's owner-contractor agreement when you have cost reimbursement up to a guaranteed maximum price. I think that the one real reason why I might think about using an A102 rather than an A101 is if the owner really needs to get a shovel in the ground before the architectural and engineering drawings are advanced to the point where a contractor is reasonably going to be able to give you a fixed price. Although even in those situations, there are some workarounds. Something that's very important to understand is that the A101-2017, the basic owner contractor agreement for a fixed contract sum project, is always paired with another very important contract document. It is always universally paired with the A201-2017 general conditions document, which is something that's often overlooked by owners of projects and their contractors alike. Whereas the A101-2017, the basic owner contractor agreement, contains the basic business deal between the owner and the contractor. Things like price, schedule, what is retainage going to be? What is the payment procedure? What are the drawings? And then any clarifications or exclusions that the contractor may build into their pricing. Whereas the A101 contains the basic business deal between the project owner and the contractor, it's always paired with the A201-2017, this general conditions document, which describes something else. It describes the way that the owner and the contractor and the third major stakeholder, the lead design professional, which is typically an architect, are going to play nicely in the sandbox together. So when owners and contractors reach for an A101-2017, one of the biggest mistakes that they can make is to overlook the fact that its sister document, the A201-2017 General Conditions, which is 38 pages long and contains a lot of essential terms, are very much a part of the A101-2017, even though it's a separate document. The A201 General Conditions document is something that I've talked at length about. I've got videos on my website that are an hour and a half long that talk about that document. But basically, it's 38 pages of essential terms that the owner and the contractor could not live without. To give you an order of magnitude, the A201-2017 General Conditions contains the word contractor in it more than 500 times. It contains the word owner in it more than 400 times. And it contains the word architect or architectural almost 300 times. So it would be a huge mistake for owners and contractors to think about their contract embodying only the A101-2017 and then closing their eyes to this essential sister document, the A201 General Conditions. To give you a flavor of some of the very important things that are in the A201 that owners and contractors need to be cognizant of is its Article 8, which discusses all things related to time and extensions of time and delay and what happens in instances of delay, when delay might be excused, when it might not be excused. Article 9 is also very important. It speaks to the payment process. In other words, what role is the architect going to play in reviewing and certifying payment applications? Article 10 of the General Conditions talks about another very important concept, which is safety. And Article 11, just to give you a little more flavor about the importance of the A201 General Conditions, talks a lot about insurance, and it goes on for more than a page and a half about insurance considerations. So what should owners and contractors understand about the A101-2017? One very important thing to bear in mind is that you have to read it in connection with the A201-2017 General Conditions. Sometimes I will get a client that will come to me in a dispute situation or a pre-dispute situation where they're looking for me to kind of stamp out the dispute early before it blooms into something nobody wants. And I say, give me your contract. And they'll hand me the A101-2017 and I'll say, great, now give me the general conditions that goes with it. And they say there is no general conditions on this project. We didn't use it. That's a huge mistake, because even if there is no A201 that is bandied about by the parties at the time that the owner and the contractor enter into their contract, it is still very much a part of their contract. It's just the off-the-shelf version published by the AIA instead of a version of the A201-2017 general conditions that might be subject to negotiation by the owner and the contractor. Because this A201 general conditions document is incorporated by reference into the A101-2017, it doesn't need to be signed. And this is one of the reasons why people can find themselves bound by this very important 38-page document, even though they never sign it. The A201 general conditions does not call for a signature, unlike the A101-2017, the flagship owner-contractor agreement for a fixed contract sum project, which most certainly does require a signature. I should mention that the A101 also comes with an off-the-shelf Exhibit A that is published by the AIA to speak to insurance and bonds. So it's very important for owners and contractors alike to make sure that they are completing that Exhibit A and giving it all the attention that it deserves. Owners are going to want to speak to their insurance broker, and they're going to want to talk to the broker and say, what kind of insurance do I need to have for my own reasons? And I want to reflect that in this Exhibit A, the insurance exhibit. But also the owner should be asking its broker, what kind of insurance do I want to require the contractor to carry for the protection of the project and for the protection of lenders and tenants and adjacent landowners and a wide variety of people. So this Exhibit A to the A101, the insurance exhibit, is a very important document for the owner and the contractor alike. Both should be paying close attention to it with their insurance broker's input, because you don't want a situation where you don't have the right insurance from your counterparty that is listed in the contract, but you also don't want to get into a situation where you accidentally promise to carry more insurance than you're actually going to carry as either the owner or the contractor, or a different kind of insurance than you're actually going to carry, because the minute that you sign the A101-2017 and lift the pen off, you've breached the contract by not providing the insurance that's required. So there's insurance terms in the body of the A101-2017. There's a page and a half on insurance in the A201 general conditions, an essential document that must be read with the A101-2017. And then there is, in addition, this A101-2017 Exhibit A insurance specification exhibit that is prepared by the AIA. That's important to bear in mind as well. Unlike every standard off-the-shelf agreement, the A101-2017 is not something, in my opinion, that can simply be fill in the blank and sign and use. Now, certainly it would be better to do that than to do a lot of other things that I see owners and contractors doing, getting into projects where the contracts are much less clear. But any off-the-shelf manuscript document, any AIA contract or any other contract, whether it's a consensus docs contract or a AJCDC document, any standard form agreement is just a starting point for negotiations, because all of these documents are intended to be kind of up the middle documents that don't favor one party or the other all that much. So when I am representing an owner and we're going to use the A101-2017, what do? I think about what project-specific edits are necessary to make to this document. What paragraphs are missing? What clauses are missing? What concepts are missing? And some of that is driven by what's the project delivery method? What's the owner's goal? Is it to get the project done quickly? Is it to have a very high standard of quality, or is not getting past a certain price point very important? And there's myriad other issues. Is it a rehabilitation job or a ground up job? Is it in a tight city lot where we're going to be constructing right up against an adjacent property? So I go through an issue spotting exercise. This is true whether I represent the contractor or the owner in negotiating an A101-2017, but this issue spotting exercise is going to drive party-specific and project-specific and goal-specific edits in the A101-2017 that are going to vary from project to project and client to client. Of course, I do have my standard set of edits that I like to put in when I represent the owner. I've got a standard set of edits that I like to try to put in that are a little different if I represent the contractor. Again, these documents are meant to be up the middle. They're meant to be a starting point. And so I take different, but in some ways overlapping approaches on certain issues to representing owners or contractors when I'm negotiating an A101-2017. This is the reason why I'm going to create 2 companion videos to this one that talks about owner considerations for using the A101 and another that talks about contractor considerations for using the A101. But it's also very important to bear in mind that the A101-2017, like every off-the-shelf contract, like every AIA contract document, it is not state-specific. It is a general document that is a starting point that can be used in many different jurisdictions, nationally, internationally, different states. And state laws are often going to dictate certain changes that are going to need to be made into the A101-2017 for the benefit of both the owner and the contractor. For example, in Illinois, in Chicago, where I'm recording this right now, there are statutes that are prescriptive, that specify what an owner must do in the payment process on a construction project to avoid the risk of mechanics liens. Same thing with the general contractor. Our state law is going to specify what sorts of things need to be done. Those concepts are not in the A101-2017. Of course, it would be impossible for the AIA to create a one-size-all document that could comply with all 50 state laws, particularly given the fact that they're going to change. So I'm going to edit the A101-2017 to contain state law imposed concepts which relate to payment, which relate to the avoidance of mechanics liens. Illinois, like many states, will impose certain restrictions on the durations and the amounts of retainage that can be held back from contractors. There are prompt payment acts that need to be complied with. Most states have certain limitations on how far an indemnity clause can go. And so while I'm a huge fan of the A101-2017, the flagship owner-contractor agreement, and while I would, all things being equal, if I don't need to get a shovel in the ground early, if the drawings are complete, if I don't think that there's a realistic opportunity of achieving savings under a guaranteed maximum price, which might send me looking at another AIA contract document, all things being equal, this is the document that I'm going to use more often than not if I'm the owner of the project. The A101-2017 Basic Owner Contractor Agreement is a fantastic document, but it absolutely will require project-specific, party-specific, and state law-specific edits after you take it off the shelf before you can deploy it on your project so that you can achieve what everybody wants, which is a win-win project, good construction for a fair price, project delivered on time, on schedule, no injuries, no disputes, and happy project participants.